Judges of the United States Court of Appeals in and for the Seventh Judicial Circuit. Hear ye, hear ye, hear ye. All persons having business before this honorable court are admonished to draw near and give their attention, as the court is now sitting. God save the United States and this honorable court.
Good morning, ladies and gentlemen. Our first case for argument this morning is United States against Smith. Mr. Shanmugam.
Thank you, Judge Easterbrook. Canon Shanmugam, Paul Weiss for Appellant Michael Novak. May it please the court. This case critically differs from the other spoofing cases to come before this court, and the court would have to extend the reach of those cases in problematic ways in order to affirm Mr. Novak's conviction here. First, this court has held that spoofing requires an unconditional intent to trade at the time the order is placed. But here, unlike in the other cases, the government failed to present sufficient evidence that Mr. Novak placed orders with that unconditional intent to
What
cancel.
would you articulate as the difference between an intent to cancel and an unintentional intent to cancel? Since to at least one pair of ears, they sound like the same thing.
Judge Easterbrook, a conditional intent to cancel would be when...
No. Our language is intent to cancel. It's not conditional intent to cancel. It's just intent to cancel. What does adding the word unconditional to intent to cancel add?
We are relying first on footnote 45 of COTA.
No, I'm asking you what the difference between these things is.
Sure. So a present intent, of course, what you're looking at is the intent at the time of the trade. In our view, the difference between an unconditional intent at that moment and a conditional intent is that you are executing the trade on the understanding that if something happens, the trade will then be canceled. Now, there's a lot of back and forth between us.
Why is that just not an intent to cancel the trade? You know, in other words, when you execute the trade, you don't have the intent to cancel the trade. That would be a conditional intent.
Judge Kirsch, that would sweep way too broadly for a simple reason. We catalog in our brief a variety of different types of trades. Perhaps the best example is a fill or kill trade. In that circumstance, you are executing the trade at the moment you execute it with the intent that if the trade does not immediately execute, if there's not somebody who immediately buys or sells, that the order will be canceled. This is no different.
But at the time you, in that case, at the time you execute the trade, you don't have an intent to cancel, do you? You have an intent. Your desire is to fill the trade at a particular price. It's not to cancel the trade.
Well, your intent at that moment is that if something in the world happens or does not happen, that the trade will be canceled. And notably, if you look at the evidence in this case, and we're happy to start with the government's own evidence, the government's own witnesses acknowledged that the four-step trading pattern here could be a perfectly legitimate trading strategy. I would point the court to pages 1427 and 2909 of the appendix. And Mr. Sniegowski, one of the CME officials who testified for the government, further testified that placing two orders on opposite sides of the market and then canceling one automatically if the other one is executed is okay. Now, the government itself, I think, conceded below, to get back to where Judge Easterbrook started, that an unconditional intent was required. The government's only quibble was that it was unnecessary to include that word in the instruction because it was otherwise included in other instructions. And so to the extent that the government is now coming in and telling this court, notwithstanding what it has said in the earlier spoofing cases, that you can kind of elide the unconditional part of this intent, I think our response would be first, that if you do that, you are going to sweep in fill or kill orders, stop-loss orders. There is no principled basis for drawing a distinction between certain conditional intents to cancel and others.
Even if we agree with you, though, doesn't your client still lose unless we find that the district court abused its discretion in admitting certain evidence?
I don't think so. Now, Ms. Shapiro, of course, will address a variety of the evidentiary arguments. But what I would say for now is that in its brief responding to our arguments, the government devotes only 3 pages to arguing that there was sufficient evidence of an unconditional intent to cancel. And keep in mind, again, that the jury was instructed that that was required. And so to the extent that the government is trying to allied the unconditional part of this, their argument fails for that reason too. But, can I just say one thing very quickly about the evidence? So our basic view here is that given that the government's witnesses acknowledged that this could be a perfectly legitimate trading strategy, the question is, what evidence moved the needle here towards it being an impermissible, unconditional intent rather than a permissible intent? And what the government points to at bottom is simply the trading pattern and how frequently the trading pattern was executed.
Isn't it also the sheer volume of number of trades that were canceled?
Well, that is the other thing, Judge Kohler, that the government points to. And I would say two things in response to that. First, the government cherry-picked 100 trades from a broader category of 3,600 trades that it said fit the four-step pattern out of the hundreds of thousands of trades that my client executed. Given that the government did that, it's surprising that the number is now actually not 0% rather than 0.22%.
And you can argue all that to the jury and say it doesn't add up to intent, correct?
But my point is simply that you cannot infer the intent from that alone, because even if the intent here were a legitimate one, it is not surprising that a high percentage of the trades would never be filled. Keep in mind that what we're talking about in the government's cherry-picked examples are these so-called scaled orders. The whole point of a scaled order in some sense is for it never to be fully executed. The scaled order is really just a hedge against the possibility that there may be a dramatic price movement. You don't want all of those scales to be executed. And there was abundant evidence in the record as to why this would be a legitimate trading strategy in light of the fact that algorithmic traders often front-run manual traders. You can execute these trades for the purpose of ensuring that those algorithmic traders are not able to effectively prevent you from trading. And also, Mr. Novak stood in a different position from all of the other traders in these prior spoofing cases because he was fundamentally an options trader. And so he used these futures trades to hedge his options trading. Now, I make that point not to get into a battle as to who was correct in front of the jury, but simply to drive home the fact that there were perfectly legitimate reasons to engage in this trading. Now, I do want to reserve 2 minutes for rebuttal, so in my remaining minute, I want to say just a word about our other argument, our argument concerning an essential element of the bargain. Our fundamental submission here is that under the standard articulated by this court in the Weimert and Courtroom case, and the standard articulated by a number of other circuits, these alleged misrepresentations did not go to an essential element of the bargain. The government's argument in its brief is that, well, you can view these trades as misrepresentations about supply and demand in the market. But that doesn't go to the price at which the commodity is being traded, and it doesn't go to any of the essential characteristics of that product. And if it did, it would sweep in a whole range of representations. The real estate agent who says lots of people have come through this house during this open house, creating a false impression of demand. The government really has no response to that. And I would note parenthetically that the Supreme Court in the Coussis case, which is currently pending and which will likely be argued in December, may very well say something about this requirement. I will reserve the balance of my time for rebuttal with the court's leave.
Certainly, counsel. Ms. Shapiro.
May it please the court. My name is Alexandra Shapiro of Shapiro, Arado, Bach, and I represent appellant Greg Smith. We join in Mr. Novak's arguments, which apply equally to Mr. Smith. But if the court concludes the evidence was legally sufficient, the convictions should still be reversed and the case remanded for a new trial because Mr. Smith was deprived of a fair trial by the district court's erroneous evidentiary rulings and responses to the jury's notes after the deadlock. I'd like to turn first to the WICA testimony and report. This evidence essentially conveyed that CME and Mr. WICA are experts. They investigated thoroughly. He found that Mr. Smith spoofed, manipulated, lacked the intent to trade, and used statutory terms, gave legal definitions of spoofing, concluded he was guilty, and essentially that was obvious. The admission of that testimony and report violated all three prongs of Rule 701. With respect to 701A, that rule requires that the testimony be based on the witness's perception but Wicca observed nothing personally that was relevant himself. He had no firsthand knowledge of anything Mr. Smith said or did. He played no investigatory role other than the statistical analysis he performed. He did not even interview Mr. Smith. Second, with regard to 701C, his testimony was plainly based on specialized knowledge. He conducted a broad statistical review of trading activity.
If he was an expert, would his testimony have been admissible?
No, Your Honor.
If he was a government agent, would his testimony have been, if he's an FBI agent summarizing the investigation that the FBI engaged in, would it have been admissible?
Not if the substance was the substance here. The difference between the testimony that Mr. Wicca gave and that type of testimony is that the investigation itself and what Mr. Wicca did was not relevant to any fact or issue in the case, except to the extent that he performed this statistical analysis, which required his specialized technical knowledge. In addition, under Rule 704B, an expert is not allowed to opine on the defendant's mental state. And indeed, in the Supreme Court's decision last term in Diaz versus United States, the court drew a distinction between the testimony in that case in which an agent in a drug case testified that when couriers have drugs, that in most cases, it turns out they knew that what they were carrying was drugs. And the court made a distinction between that type of testimony and testimony in which an agent would draw a specific conclusion as to the particular defendant, because the more general testimony allows the jury to draw the inference, whereas, and here Wicca's testimony was very specifically about Mr. Smith. He testified over and over again that he had concluded that Mr. Smith lacked an intent to trade and had engaged in a pattern of spoofing. And what's more, the government really hammered that point home in closing. It clearly affected the outcome. They repeatedly said in both their initial summation and the rebuttal that he had no skin in the game. He was unpaid. They emphasized that the CME, he had testified that the CME flagged Mr. Smith's trades for spoofing, said that Mr. Wicca demolishes.
Are you arguing there the use of the term spoofing, or are you arguing that Mr. Wicca testified as to your client's intent, or is it a combination of the two?
It's a combination of the two because
he's describing spoofing?
Because he's describing spoofing and the legal meaning of spoofing, which is clearly
But what about an ATF agent in a case where there's a possession of a stolen firearm, for instance, and an ATF agent testifies that the firearm was stolen? Of course, that's an element of the offense. So the jury checks the box, the firearm was stolen. Everybody knows what stolen means. It's a common term. We know what it means. Spoofing is a little bit different. Jurors don't necessarily know what spoofing is unless they're told what it is. Isn't that a difference in a witness testifying that I think this was spoofing?
Well, Your Honor, just I want to make sure I understand the hypothetical. I mean, I don't think under 701, an ATF agent could give his personal opinion as to whether
Just a fact.
the firearm was stolen.
Right, it's just.
But that would be hearsay. So you'd have to have the person whose firearm it was come in and say that it was stolen. I'm not sure I understand how.
Well, I mean, I don't think you'd have to have the person come in to testify that the firearm was stolen.
Well, there'd have to be some non-hearsay basis for that.
The point of the question was that if a witness uses a legal word, does that person have to be an expert? Suppose the person who owned the firearm shows up and says, he stole my gun.
No,
Is
Your
that
Honor.
witness disqualified because stole is a legal word?
No, not necessarily at all. But our point here is that Wicca's testimony was extraordinary because not just because it failed the helpfulness prong of 701, which is B, which is the one that essentially corresponds to Rule 704B, but because he lacked any personal basis for it under 701A, and his testimony the substance of his testimony was based on a complex statistical analysis based on his knowledge and understanding of how this market, which is very complex and beyond, ordinary lay understanding, worked. And so his testimony was extraordinary in that regard. And he also
But I get that. It's better for the defense if the jury doesn't know what spoofing is. It makes it harder for the government to prove their case, right? If no witness can explain to the jury what is spoofing.
well,
But why can't they do that? I mean, I'm confused on that. Like, would the hypothetical about the stolen firearm it makes no difference. Somebody's got to testify the gun was stolen, right? Whether it happened on the train and he took the gun away from me, and the jury then.
Well, you don't need to use the word, but the more important point is that this witness testified over and over again that Mr. Smith lacked an intent to trade. Essentially, he was opining on the defendant's mens rea. And he also used the word manipulation. He told the jury that Mr. Smith was guilty. And there are numerous examples of this that just go way over the line. For instance, if the court examines the portions of, and I see I'm almost out of time here, of his testimony in which he's asked about Mr. Smith's deposition, the government starts off by saying, in your investigations, do you interview defendants and does that help you decide to close cases? And then after laying that groundwork, he goes on to ask the witness whether he's read the deposition and whether he closed the case. No, he didn't after reading it. And why was that? And the witness starts to say, because I didn't believe, and then that's cut off. And then but the jury heard it. That's just one example, but he just over and over again went to the heart of Mr. Smith's mental state, his intent to trade, and then the government, as I indicated, hammered that home in closing as enough to convict. I'll reserve the rest of my time. Thank you.
Mhm. Certainly, counsel. Mr. Benjamin.
May it please the court. My name is Jim Benjamin, and I represented Chris Jordan at trial. Mr. Jordan's trial was very different from that of his co-defendants. The key question for the jury in Mr. Jordan's case was not whether he spoofed, but whether he acted with a guilty state of mind. The government argued that Mr. Jordan acted with a criminal intent to defraud, and the defense said no, Mr. Jordan acted in good faith. To make a reliable determination on that question, the jury needed to hear admissible evidence from both sides in a fair and even-handed manner. Unfortunately, that did not happen. The presentation of evidence was distorted, significantly distorted, because of the district court's erroneous evidentiary rulings, in particular the Rule 106 error. During the cross-examination of Agent Luca, we sought to elicit Mr. Jordan's statement that when he spoofed, he didn't think what he was doing was wrong. Now, the facts on that were undisputed. To his credit, Agent Luca recorded that exculpatory statement by Mr. Jordan right smack in the middle of the key portion of the 302. But the government refused to elicit that portion of the statement on direct, and they objected on hearsay grounds when we sought to do so on cross. The evidentiary question was governed by Rule 106, the rule of completeness. On appeal, in reviewing a Rule 106 question, the legal standard is well settled. It has two parts. First, was the excluded part of the statement relevant to an issue in the case? And second, if so, should it have been admitted to prevent distortion and to ensure a fair and impartial understanding of all of the evidence? Applying that standard, the district court plainly should have allowed the exculpatory part of Mr. Jordan's statement to Agent Luca. That portion of the statement that Mr. Jordan, quote, didn't think what he was doing was wrong was obviously relevant. It went directly to Mr. Jordan's state of mind, which was the central disputed issue at the trial. And the denial of bad intent was necessary to avoid distortion and to prevent the jury from being misled. This was clear right from the government's opening statement when they wrongly characterized Mr. Jordan's statement as a confession. A confession to spoofing? Maybe. A confession to wire fraud? Absolutely not. It's not a confession when the person being interviewed denies acting with the requisite state of mind. Sitting here today in this courtroom, all of us know the truth about what Mr. Jordan said to the agents, but the jury was in the dark. With its ruling on Rule 106, the district court gave the government a license to rewrite and re-engineer Mr. Jordan's statement to serve the government's purposes,
Mr.
and they
Benjamin.
went in.
Can I ask you a question? What's the limiting principle of your argument? Is there one, I mean, in every single public corruption investigation, defendants or anything, they all say they did nothing wrong. Every one of them, every single one of them. They describe, I accepted this payment or I accepted, but I didn't think what I was doing was wrong. They say it over and over and over again. And that testimony is almost never admitted. They don't have to testify. They're not subject to cross-examination. That would be wonderful. I mean, when I defended cases, I would have loved to got that evidence. I've never put anybody on the stand. You know, my client, an FBI agent went, did he deny that he was doing? Yes, he did. Did he deny it? Yes, he did. Yes. And it's just terrific. But I don't know that that's the way the rule of completeness works, is it?
Well, Your Honor, I think it's well settled in this court's precedents, and there's an ample body of case law. It's context dependent. It depends on the proximity of the excluded part of the statement to the admitted part of the statements. It depends on the relevance. And ultimately, is it necessary to avoid the jury from being misled? According to the agent's testimony, Mr. Jordan said that he spoofed for 3 reasons. 1, to outperform algorithms. 2, to achieve good execution for his boss. And 3, according to the agent, to, quote, mislead the market. Now, those first 2 reasons are clearly innocent, and the omitted portion of the statement would have allowed the jury to find that the 3rd reason was also innocent. That is because in the context of
was Judge Chang right to be concerned about mistake of law in that context?
Your Honor, I really don't believe so. I will say I frankly didn't really understand his single-minded focus on this. We disclaimed any intent to rely on mistake of law. We stuck to that representation. We elicited no evidence. We made no arguments in that regard. And in the entirety of the 7-page single-space 302, there's not a single mention of the law or Dodd-Frank. Mr. Jordan's not a lawyer, neither are the agents. And if I may just return to the point I was making, because I think it's really important. In the context of trading, acting to mislead a competitor is not necessarily wrongful. Trading is competitive. The goal is to keep your competitors off balance, to conceal your true goals and intentions. And there was ample evidence on that point, including the testimony of Mr. Scheer from the CME and evidence that the markets were in a time of transition with intense competition between human traders and algorithms. And in the text of the 302 and Judge Kirsch, again, I think it's very context dependent, but the 302, it's right there. It shows these 2 statements are complementary and intertwined. They're not contradictory. It really was probative, directly probative of his good faith, which was our
Maybe
defense.
that's the answer, right? That it overlaps with the government's burden to prove an absence of good faith.
Yeah, for sure. And that was the defense, and it was the disputed ground at trial. And I would note as well that, you know, this was a thin case on intent. There were no cooperators. Unlike every other spoofing case to come before this court, the government did not call a single cooperator. The e-coms, again, in some of the spoofing cases, that testimony has been very, very damaging for the defense. In our case, the e-coms were exculpatory. They showed Mr. Jordan talking openly about this practice. Mr. Jordan was forthright with the agents, right? Agent Luca testified that he was candid when he was asked about it. And so against that backdrop, the evidence and the government's argument about the so-called confession, it was the central piece of evidence in the case. In the rebuttal, they said that if the jury should convict based solely on what they call the confession. And that tracks, by the way, with our common understanding of how trials work and with the Supreme Court's statements in the Fulminante case. If the jury had learned the truth, we know it, they didn't. If the jury had learned the truth that Mr. Jordan said his conduct, he didn't think it was wrongful, it would have tracked with the other defense evidence. In the language of this court's decision in Williams, the case would have been significantly less persuasive in the mind of the average juror. I see with 20 seconds to go, I'm loath to start on another topic. And so with the court's permission, I'll reserve the rest of my time for rebuttal.
Certainly, counsel. Mr. Glazer.
May it please the court, William Glasser for the United States. The evidence here was sufficient to support the convictions for spoofing, wire fraud, commodities fraud, and price manipulation, because the facts were extremely similar to the 3 other cases in which this court has upheld convictions for those same crimes. I'd like to start with the question of this unconditional intent. The government's position has been consistent from trial until now that unconditional is not a necessary separate element of the offense. It's essentially redundant, but it can become misleading if understood as the defense would have this court interpret it. So as the the fraud attorney said at trial, I worry that unconditional would create more confusion than value for instructing them on how to assess content. The prosecutor also said, I'm slightly worried that by putting unconditional, it's suggesting a sort of raise of the government's burden on this element. That's the same argument we're making here, that the focus should not be on this word unconditional, but rather on the lack of a good faith intent to execute and the presence of an intent to cancel before execution. That was our position, that unconditional was essentially redundant. Now, I don't want to push too.
Mr. Glasser, let me ask you a question about Mr. Benjamin's argument regarding the lack of good faith.
Okay.
When you have a case like this one, where it's the government's burden to prove a lack of good faith, right? I mean, there's no necessity for a separate jury instruction because it's included in the wire fraud instruction.
Yes, Your Honor, to a certain extent. So to the extent we have to prove intent to defraud, then absolutely we have to show an absence of good faith.
Because if you act in good faith, then you almost necessarily don't have an intent to defraud.
That's correct.
Right? So when a defendant or a witness is describing facts, I did this, I did A, I did B, I did C, I did D, but I didn't do them with any intent to commit fraud. Why is that last statement not necessary to the context and the understanding of I did A, I did B, I did C, I did D, particularly when the government has to prove not just that the defendant did A, B, C, and D, but the defendant did them with a bad intent. Does that make sense?
It does, Your Honor. And I think that this would have been a different case if the testimony had been, I did this without intent to defraud. But he said the statement was, he did not think what he was doing was wrong. And that's different than intent to defraud, because he admitted that he took actions that were intended to mislead the market. And so if you intend to mislead the market and to obtain money or property through spoofing, then it really doesn't matter whether you think it was wrong. I think as the point you were making, Judge Kirch, every defendant thinks, in some way or another that what he was doing is not wrong. And so if you defraud a bank because you think that the bank has more than enough money, and so it's not wrong to defraud the bank, that's not a defense. So I think that's an important distinction there. His statement was simply that he didn't think anything was wrong. Returning to the issue of the unconditional intent, I think we do agree to some extent with the defense in that we recognize that there are certain instances in which the conditional intent may really be what distinguishes legitimate trading from illegitimate trading. And so we actually think we can show unconditional intent in the spoofing context, as the government's expert testified and as this court has recognized 3 times in prior cases. There really is no legitimate business reason to place huge visible orders on the opposite side of the market from the side that you want to execute. And so the only reason that you would place those orders is with the intent to cancel them, regardless of market conditions. But the reason I think unconditional can be misleading and is sort of a camel's nose for the defense here to raise the government's burden is that if you look at page 31 of Mr. Novak's opening brief, he points to a condition that is that he alleges, prevents us from proving an unconditional intent that is really part of every spoofing case. So there he says the 4-step pattern even taken as a whole, indicates at most that the allegedly deceptive orders were placed with the conditional intent to cancel if the order on the other side was filled. Well, filling the other side is always the point of a spoofing case. And so if that is enough to be a condition that prevents the government from meeting its burden, then spoofing isn't a crime. And that flies directly in the face of this court's precedent. Now, I would, if the court will allow, I'd like to take time to look at the actual evidence we have here of the unconditional intent, or as we would put it, the intent to cancel before execution, as opposed to a good faith intent to execute. So
Can I ask you a question on a different subject? What's the government's position on whether essential, whether the essential element of the bargain is an element of what's the government's position on that?
Your Honor, I think our position will be spelled out a little bit better than I can probably do it in the Coussis brief that's, I think, due in about a month for the United States, but I'll try and give my best shot. So my understanding of the government's position is that at sort of one level, an essential element, we agree that fraud or misrepresentation needs to go to an essential element of the bargain. But we would put that under the heading of materiality. I think that's what this court essentially did in the Chanu case when at least implicitly rejecting the similar argument here in the spoofing context. So we agree that if you make a misrepresentation about something that is collateral to the bargain, sort of far removed and doesn't matter, then that's not fraud. The reason that we disagree with some articulations or understandings of the essential element cases is that some of those cases have said that there has to actually be intended harm to the victim. So in other words, if you give someone something of equal value to the thing that they think they're getting, then they haven't been defrauded. And we think that that's just an improper understanding of what fraud is. So if, for example, you sell someone a car saying it belongs to Winston Churchill, knowing they wanted a car that belonged to Winston Churchill, and it actually belongs to Joseph Stalin, then in our view, that's fraud, even if the car is equally valuable because it belonged to someone else. So that's, I think, our understanding is, yes, essential element is part of materiality, but essential element can be misunderstood to mean that you have to intend harm. And we think that's inconsistent with the Supreme Court's cases that have said that harm is not, harm or even intended harm is not an element of wire fraud. If I can turn to the evidence here of an unconditional intent to cancel. Again, as I mentioned earlier, the whole framework of spoofing, the only reason that one enters those spoof orders is to execute on the other side. And so you're not, when you're trying to sell and you place a huge buy order, you intend to cancel that before execution, or you're going to hurt your position in the market. So although the defense says that this court shouldn't look at the nature of spoofing itself or that four-step pattern, I think that's absolutely what this court has done in cases since Kosha, has said the pattern itself, the way spoofing works, is that you intend to cancel essentially no matter what. And I think that is supported here by all of the testimony, both from the government's expert and particularly from the cooperators. I think the cooperators' testimony here is key because
I'm stuck on wire fraud. So let me help me with this. The way I understand this is if you're spoofing, you're driving up the price, right? So you're driving up the price, in this case, gold. You're driving up the price, and then you ultimately sell the gold at a higher price than you would have obtained if you hadn't driven the price up. Right?
Yes, Your Honor.
It's just that simple.
Yes, it can also work going down, but absolutely,
right,
I
but
agree.
Let's just take going
Sure.
up. You want to sell it at $1, and you drive the price up, and you ultimately sell it at $1.10. Somebody on the other side of the trade buys it for $1.10, knowing they're buying it for $1.10.
Correct.
Right. So how is that different than like Weimar? When it comes to wire fraud, how is that different if a real estate agent is trying, I sell a house, right? I sell a house. I want to get $100,000 for it. I tell the real estate agent, I take $85,000. Okay.
Sure.
And the real estate agent tells a prospective buyer, Kirsch won't take $1 less than $90,000. And they pay $90,000 for the house. How is that wire fraud?
Your Honor, we wouldn't say that that is wire fraud. And I think
What's the
so.
difference?
So the difference, Your Honor, is that in this case, you're not simply misrepresenting your bargaining position. So it's not that Mr. Novak and Mr. Smith were somehow sending a signal through an anonymous market that they were only willing to trade at a certain place. What they're doing is they're manipulating the entire market. So I think a closer analogy would be someone who hacks into the multi-listing service and changes the comps for all the houses in an
Where do
area.
you find that in the elements of the offense?
Your Honor, I think we would relate this to materiality. So if you misrepresent your bargaining position, I won't take anything higher or lower than this, then that's not material, because everyone understands in a bargaining transaction that you can conceal your bottom line, but it is material if you have misrepresented the entire market. Again, this is an anonymous exchange. And so what they've done is they have changed, through taking over the visible market book, they have changed the appearance of where trades are happening and actually caused trades to happen at a different place. So it's very different than an arm's length transaction between realtors. Here, they're actually manipulating the entire market.
Boy, that makes materiality do a lot of work. I mean,
Well,
a lot more than it's ever done in the past.
Your Honor,
in any of these cases.
I don't think it does. I think if you look at the Chanu case, in which the defendants raised the exact same argument. They claimed that there was no misrepresentation as to an essential element of the bargain. They relied on Weimert. They cited the same out-of-circuit case law that the defense does here. And this court, although it didn't use the words essential element in its ruling on materiality, I think this court essentially treated the essential element argument as part of materiality. And the court, citing Weimert, says these are material misrepresentations because they're misrepresentations as to the entire supply, demand, and depth of the market.
Would the government take the position that spoofing necessarily equals wire fraud?
Spoofing necessarily equals wire fraud?
If you're convicted of spoofing, you're guilty of wire fraud as well.
Your Honor,
Some criminal offenses work that way, right? I mean,
sure. The elements are different. I think in the vast majority of cases, I'm trying to think of a situation in which there might be a difference between them. I struggle to find
It's
one.
hard to think of one.
Agreed. So if I can return to the evidence that we have here of an unconditional intent, Edmonds, one of the cooperators, testified about his own trades. I decided to cancel them before I even placed them. That's at Appendix 1780. He said, I was rapidly clicking so fast that I probably was filled on my sell orders before I realized I was still done clicking. That's at Appendix 1043. And he said, it's impossible to make a decision in that short a period of time. Appendix 1781. Now, Edmonds and Truns, both of the cooperators, testified that they saw Smith and Novak spoof with their own eyes on multiple occasions doing the exact same thing. So although we don't have any smoking gun evidence where Mr. Novak or Mr. Smith said, I am placing this order with intent to cancel, with unconditional intent to cancel before execution, we don't need that. Again, this court has upheld spoofing convictions under very similar facts, where admittedly we had chats that used words like spoofing. Here we don't have chats using words exactly like spoofing, although we do have Truns telling another trader that Mr. Smith was, quote, bidding it up, which I think is essentially the same thing. But we don't need to have that kind of direct evidence of criminal intent, particularly under the facts of this case, where there's simply, as the government's expert testified, no rational trading strategy that would require you to place small iceberg orders on one side of the market and large visible orders on the other side of the market. Now, the defense suggests that there may be some other possible legitimate types of trading going on there, such as hedging. Again, the cooperators here testified that there's no rational hedging strategy in which, in order to get flat, you place orders on both sides of the market. So, for example, Truns at Appendix 3131 said that placing orders on opposite sides of the market is not part of a legitimate options hedging strategy. He says it makes no sense to me because as a hedging strategy, usually with options, you have a delta. You're either long or you're short. You're not both long and short at the same time. So again, although the defense, relying mostly on the cross-examination of the government witnesses, suggests that there were a variety of legitimate trading strategies, that Mr. Novak and Mr. Smith could have been engaged in. If you look at the whole of the evidence here, particularly the direct testimony of all three cooperators and the government's expert, it's very clear that this was not a legitimate trading strategy and that they engaged in these trades with the intent to cancel unconditionally, regardless of market changes. I think it's also worth noting that Mr. Novak told the Commodity Futures Trading Commission in 2010 that he did not put up bids he didn't intend to execute and then pull them down. He said that would not be appropriate to deliberately show very big bids and very big offers without the intention of trading. The fact that he told that to the investigators indicates that he himself knew that it was not something you were supposed to do.
Did the government go too far with Mr. Wicca's testimony? In other words, was this more akin to hybrid testimony where there was some expert opinion testimony and some testimony that he was, testifying just to facts in the case where it wasn't opinion testimony?
Your Honor, no, the government did not go too far. I think even if it did, an error would be harmless. But the reason I don't think the government went too far is that although Mr. Wicca was not the person who initially opened the investigation when the CME group received this complaint about market manipulation, and by the way, I'd like to point out that complaint was not specifically about Mr. Smith because it's an anonymous market. It was just a complaint about market manipulation. And they started looking at trades. They found, Mr. Smith seems to be engaging in this conduct that's called spoofing. The reason the government called Mr. Wicca was in order to rebut the defense claim that this understanding of spoofing was just something sort of made up by DOJ lawyers, but to show that the CME group itself was concerned about spoofing. Although he wasn't there at the start, Mr. Wicca was the person who took over the investigation, prepared the final report for purposes of helping the CME group determine whether or not there had been spoofing. So he was testifying about his own investigation. He wasn't sort of coming in as an outside expert the way that Professor Venkatraman did. And he was testifying about facts, the facts of his investigation. Now, it's true that he described spoofing. I think, again, other fact witnesses, the cooperators, described spoofing as one must do when describing criminal activity. But he didn't go too far. And I think it's important if you...
The problem with that isn't when you describe spoofing. Spoofing necessarily entails intent. And so when you describe what is spoofing to the jury, you're telling the jury that the defendant acted with bad intent. And then when you're concluding for the jury that the defendant engaged in spoofing, you're telling the jury, not only does the government have to prove bad intent, but they did it in this case.
Well, Your Honor, I mean, it is true. He didn't testify that Mr. Smith or Mr. Novak had intent. What he did say was, when you spoof, you intend to cancel before execution, which again, this court has said it's kind of a well-known thing. That is what spoofing is. And then he said that we recognize the pattern with Mr. Smith that appeared to be consistent with spoofing. So yes, if you combine those two steps, you could say he's testifying as to criminal intent, but I don't think that's impermissible, and it's certainly not expert testimony. And I would like to note that if you look at appendix page 242, the district court, in denying the Rule 29 motion and Rule 33 motion, pointed out that as an abundance of caution, the court offered to have the lay opinion witnesses, including Mr. Wicca, clearly divide their testimony between fact and opinion, and offered to give a cautionary instruction to the jury. The defense declined that cautionary instruction, but the district court gave that as one more reason why there was no concern here with the testimony going beyond the proper bounds of expert testimony or venturing into testimony about the elements of the offense. Just to briefly sort of close the loop on the evidence that we think is sufficient to show unconditional evidence, unconditional intent to cancel, it's also helpful to notice that Mr. Novak told Truns before his compliance interview, remember every order you put into the market you intended to trade on. The fact that he gave that reminder seems to indicate that he recognized that you're supposed to have intent to trade, and perhaps that the conduct they were engaging in did not involve intent to trade. He and Mr. Smith, Edmonds testified, Mr. Smith told him showing size moves the market. He yelled, they're effing hitting me, and threw his glasses at the screen when his spoof orders were executed. And again, Truns messaged another trader saying that Smith was bidding up the futures to try to get some off. So we don't have the exact same evidence in this case that we had in Kosha, in Chanu, and in Pacilio, but the evidence is very similar, and a reasonable jury could conclude beyond a reasonable doubt that the requisite intent to cancel was present here. Again, they received the jury instruction they wanted with unconditional in it on the spoofing count, and there's just no basis to believe that the evidence is insufficient to show the requisite intent. I think we've covered Mr. Wicca's testimony, unless the court has further questions on that and the essential element. So I think the final thing I'd like to turn to, again, we may have covered it to some extent, is this concern that Mr. Jordan was prevented from introducing testimony about his own good faith. Again, as I mentioned, the fact that you don't believe that what you were doing is wrong is not a defense to the crime. And so the evidence was sufficient. All the evidence was properly admitted in this case. Again, we have harmless error arguments to back up all of the evidentiary errors.
On that though, all the evidence you went through on intent for Smith and Nowak, that's not all applicable in Jordan's trial. You narrowed it to wire fraud, and the evidence is different.
Certainly, Your Honor. And so I don't want to suggest that they're the same. What I think is important is that Mr. Jordan, he admitted that he spoofed. So he said, I did this with intent to mislead the market. It's just his defense was he didn't have the intent to defraud because in his view, he didn't know that what he was doing was wrong. And I think here it's useful to look at the fact that he also, when speaking to investigators, said that he denied engaging in this kind of conduct, and then later he admitted it to the FBI. So it's just implausible. So not only is it not a defense to say that I didn't know what I was doing is wrong, but it's also just implausible to say that he didn't have the requisite intent when he denied engaging in this conduct and then later admitted to engaging in it and just said, well, but I didn't think what I was doing was wrong. Unless the court has further questions, I'm happy to yield the remainder of my time. We'd ask the court to affirm as to all three defendants.
Thank you, counsel.
Thank you, Your Honors. Why does this case matter? It matters, of course, to the three appellants, but I would submit that it is, in fact, of much broader significance. Why is that? Well, as Mr. Glasser conceded a few minutes ago, in the three previous spoofing cases to come before this court, there was actual evidence of intent. In Chanu and Pacilio, direct evidence of intent in the form of smoking gun chats. In Kosha, a software program designed to ensure that certain trades would never execute. We don't have that here. And leaving aside the very weak evidence from chats, which we address in our reply brief at pages 15 to 16, all that the government has to prove intent here is the conduct, the trading pattern, and various aspects of that pattern. But the government's own witnesses said that it could be a, quote, perfectly legitimate trading strategy. And I don't know why the fact that they said it on cross-examination is of any significance. In Kosha, this court said that the intent requirement, that unlawful orders are those placed, quote, with a present intent to always cancel, end quote, rather than the, quote, intent to cancel under certain circumstances, was the critical element that saved the spoofing offense here from vagueness. And Mr. Glasser suggested that some conditional intents are okay, but others aren't, but he didn't offer a principled basis for that distinction. And with regard to the essential element of the offense, Mr. Glasser gloriously punted to his colleagues on the 5th floor of the Justice Department and the SG's office when Judge Kirsch asked whether the government thinks that that's required. So I guess we'll wait with bated breath to find out what the government's position actually is. The final thing I would say is that if this court erodes the intent requirement, either by watering it down or by saying that the evidence here was sufficient, it will criminalize a wide range of ordinary trading in the futures markets and have a chilling effect on an even broader range, conventional trades like fill or kill orders, stop loss orders, iceberg orders, and the like. And so for that reason, we would submit that Mr. Novak's conviction should be reversed or vacated. Thank you.
Thank you.
Just like to make two quick points. First, with respect to whether Mr. Wicca was a proper witness because he testified about the purposes of the investigation. Those were not relevant to the jury's determination to the extent his testimony relied entirely on hearsay, which experts are allowed to do, but lay witnesses are not. And second, with regard to my adversary's claim that there was no testimony directly about Mr. Smith's lack of intent to trade with the large orders, that's simply not true. And we've given numerous examples in our brief of testimony about Mr. Smith, but I'll just give the court two specific examples. If you look at appendix page A, 2778, there's testimony about a large pattern of spoofing activity by Mr. Smith. Also, the court can examine the report, which concludes, and this is at page A118, that he employed a strategy that appeared to consist of entering and canceling large orders without the intent to trade with the purpose of misleading market participants. The lack of an intent to trade, the government claims, is the mens rea for this offense, and that if they proved that, they proved all of the counts. Lastly, I just want to point out that if the government's arguments are accepted here in future cases, it will be able to simply call investigators who would testify that they examined evidence collected by others and concluded the defendant is guilty and offer the reports memorializing their conclusions. That is not consistent with the rules or the Constitution, and Mr. Smith's conviction should be reversed. Thank you.
Thank you, counsel.
May it please the court. My adversary argued that the excluded portion of Mr. Jordan's statement would have been admissible if he had said, quote, "I lacked intent to defraud," but not if he said, quote, "I didn't think what I was doing was wrong." That distinction is fine. It's legalistic. It has no basis in the case law or in common sense. The case law asks,
Why does
is
it
it
have no
relevant?
basis in the case law? One of them sounds like a claim of lack of intent, and the other sounds like a mistake of law claim. I tried to deceive them, but I thought it was legal to do that. And a mistake of law claim is just irrelevant.
Your Honor, again, the case law instructs that we need to look at the context of the statement. There is nothing about law in this FBI interview, nothing whatsoever. What is in the interview, and it's immediately proximate to that statement, as the case law tells us is relevant, is there was no clear compliance rules. The orders were fully at risk. I was trying to achieve good execution on my orders. I was doing my job as a trader, okay? That is, and again, this is a unique case to come before this court. The entirety of Mr. Jordan's conduct occurred in 2009 and 2010. There was nothing in the compliance policies about this, okay? So the case law tells us to look at the context of the statement. There was nothing about law. That was not our defense. It was not implicated by the statement. Consciousness of wrongdoing is the foundational aspect of intent in a wire fraud case. The government knows that. In Chinoo, they told the jury it was.
Suppose this is a bank fraud case, and the defendant says, I have $5 million in assets, when in fact, he has only $500,000 in assets. The bank makes the loan, and he says, well, I didn't intend to harm the bank. I thought this was okay because I really plan to pay it back. But what he's done is deceive the bank about his creditworthiness. Right. Why should it matter that he thinks that he's behaved appropriately?
So the context, again, is with respect, is entirely different. And that is what Rule 106 is all about. Here, the context is not some mistake about what I intended to pay back. It's, did I think it was wrong to engage in this trading practice?
That's what the bank customer says. I didn't think it was wrong to lie about my assets because I planned to pay back.
Well, Your Honor, first of all, Mr. Jordan, as I said in my main argument, acting to mislead the market, that is not necessarily wrongful. It might be, but that was really a jury question. They should have had the chance to hear that Mr. Jordan's words. And again, in the context of the government standing up 20 times talking about confessions.
Thank you, counsel. Thanks to all counsel. The case is taken under advisement. Our next case for argument is Schoper against Western Illinois University. Mr. Yokich.
Thank you, Your Honor. May it please the court, my name is Steve Yelkich and I represent the plaintiff appellant in this case, Dr. Sarah Schoper. I'm going to spend the bulk of my time on the legal principles involved in this case, but before I get to the legal principles, I'd like to highlight a couple of important facts that I think underlie those legal principles. The university in this case demands that somebody going up for tenure be a superior teacher. And they have a numerical rating system. If you have scores of 3 to 4, you're a highly effective teacher. If you have scores of 4 to 5, you're a superior teacher. And if you're an absolutely perfect teacher and have a blanket score of 5, you're an excellent teacher. Prior to Dr. Schoper's traumatic brain injury, she had very, very strong ratings from both her students and from her faculty and department chair reviews. In her classes, for example, her student ratings exceeded 4 in 19 of the 21 classes that she taught.
Mr. Yokich, did your client ever ask for an accommodation?
Yes.
No, the way I understand it, she had to attain a certain number in the year in which she was considered for tenure, and she didn't attain that number. Before she taught that year, did she ask for an accommodation with respect to her traumatic brain injury?
She asked for an accommodation after the first round of reviews for tenure. She went to her department chair and said, if I could have more time to submit my application, I could show that I'm meeting the university's criteria.
So the accommodation was not that she didn't have to attain the certain score
Correct.
in a particular year. The accommodation she requested was an additional year.
That's right. Well, actually, all she really needed was to have the scores from the semester she was in, the spring 2017 semester, considered with her application. Because if you had considered the scores that she obtained from her students and their ratings in the spring of 2017, those scores would have put her over the superior criteria for tenure. And you know, I think the fact in this case that is very important on that point is the fact that under the system they have at Western, you are entitled to a terminal year after tenure is denied. And so it would not be unreasonable at the very first stage of the tenure process for somebody to say, look, I need more time because I'm doing very well this semester, and I think time will tell that I'm doing well.
And counsel, the CBA allows for a pause, and then you're talking about this in terms of an accommodation, but was any accommodation requested or any additional time requested before the decision was made regarding tenure?
So under the collective bargaining agreement, you can request to use something called stop the clock. And that gives you extra time to achieve tenure. You don't have to achieve it within the normal 6-year period. You might have an additional year. There were 2 problems with that in Dr. Schoper's case. One problem is that the stop the clock procedure must be invoked a year after your life event. Well, she suffered a traumatic brain injury on January 6th or 9th, 2015. That meant that stop the clock had to be invoked by January of 2016, which was really before she got her initial round of student evaluations from the first fall that she returned to work. So she didn't know the situation when she should have asked for stop the clock. Second, I would say that Dr. Schulper was under the very reasonable belief that when her application for tenure was considered, that they would look at her teaching scores for her entire period of employment at Western. And that proved not to be the case. And the first time she knew that that would not be the case was after the first round of evaluations, the one from their department personnel committee and the one from her department chair. And at that point in time, when she learned that the focus would be on only the evaluations that she had received since she returned from her traumatic brain injury, she did two things. Number one, she submitted a letter from her neurologist to the personnel committee. The neurologist said she's improved a great deal. She'll continue to improve. Second, she went to her department chair and said, I would like some extra time for my improvement to be considered.
Isn't that too late under our case law? Isn't that too late to request an accommodation?
I don't think so. Under your case law, if I drive a police car owing to my disability in a very unsafe way and I get fired, that's too late. Okay.
But isn't that what happened here? I mean, isn't it, she was denied tenure and then she requested additional?
No, what happened here, the tenure process is a many layered process. You have the department recommendation, you have the college recommendation, there's a university recommendation, and then the president decides. In this case, at the very first step of the process, she said there is a problem. After she received her departmental reviews and after she received the first review from the department chair. And in both cases, she wrote to them and said, there are issues here that I would like to address, as I indicated.
That's my concern. It'd be interesting. I don't know the answer to this question, but in the history of the academies, has any department recommended a teacher not receive tenure, but the teacher then received tenure? You know, I mean, the process is the department first recommends you for tenure, then it goes to the college, they recommend you for tenure, then it goes to whatever, the school, and I'm making this up, right? Then it goes to the president, then the board of trustees, whatever. But once the department says we're not going to recommend you for tenure, that's it. I mean, once you get a bad review, that's the end of the process.
Well, in the process at Western, if the department doesn't recommend you, you can ask for the college to reverse the department's recommendation, and you can ask for the university committee to do that as well. And in this case, the university committee actually did reverse the recommendation. They said, we think Dr. Schulper should get tenure. And it went on to the next step. And at the next step, all the president said was, well, I'm taking into account everything that happened before me, and I agree that she shouldn't get tenure. So it's a very unspecific, vague, you can't really figure it out reason. If you go back to the facts of this.
That's a problem for you as well, I think, because that goes to but-for causation, right? Because when the president said, I'm taking into account everything that is before me, there were things before the president that had nothing to do with the traumatic brain injury.
I think that but-for causation would be important on the discrimination piece of this, but I don't think it's important on the reasonable accommodation piece of this, because there's no dispute that with respect to the reasonable accommodation piece of this, that she asked for more time and the department chair said, we can't do it. And because the department chair said they couldn't do it, that was the end of the story in terms of a possible reasonable accommodation. And that's why I think if you look at the case law on reasonable accommodation, it says you can ask for it at any time in your employment. And that if the first set of reasonable accommodations doesn't work, you can ask for more. And that's what happened in this case. There were an initial set of reasonable accommodations that occurred right when she came back to teaching. And then after she realized that she wasn't popular among her students, she said, well, I need an additional reasonable accommodation, and that's to have some more time to show what I'm doing. And I think this case is much different than the other cases that are relied on by both the university and the district court. Because it's not a case that involves misconduct. And it's not a case where the plaintiff is saying, I want to get out of jail free. And it's not a case where we're asking the employer to maintain somebody in their employment for longer than they otherwise might have done it. So, for example, in this case, if she'd been able to put off the final tenure decision until her scores from the spring that she was in were considered, she might have achieved tenure because those scores would have put her above the threshold. Similarly, if she would have if during the terminal year, she had been considered for tenure as opposed to in the year before her terminal year, her scores likewise would have been much higher because they would have had the scores from both the spring of 2017 and the fall of 2017, which were exceptional and very much in the range of her prior scores. It's impossible in this case to get around the fact that her scores were really high and really strong before the traumatic brain injury, that they went down when she went to work after the traumatic brain injury, and that they rebounded. So the only issue really, if you step back and you look at what happened here, is did the university have the right in March of 2017 to say, we're not going to consider your request for reasonable accommodation? And given the fact that she was entitled to a terminal year to teach anyhow, the idea that there was some exigency that required the university to make up its mind at that moment does not, in this case, give the university any support. As I mentioned before, the case law and the policy of the ADA is, number one, that you have to bend your rules occasionally. That's the whole idea. And the case law is that a request before the end of your employment is usually has to be considered by the employer. And the case law is that if the accommodation the first time doesn't work, you're entitled to request more. And the case law is finally that the employer is required to engage. Now, if the employer had engaged in this situation, there were a lot of different results that could have happened. But instead, there was a summary rejection of the request for additional time. So I think that we have made out the elements that we need to make out to survive summary judgment on the reasonable accommodation claim. And I think that the district court's decision to the contrary is really contrary to the law and the policy of the Americans with Disabilities Act. We also have in this case a discrimination claim. And the discrimination claim is based upon the notion that the customer preference of the students can't be the reason why you make an employment decision in a case such as this. And again, that goes back to what I think is the most notable portion of the facts in this case, that she was doing exceptionally well before her traumatic brain injury, and that she had a decline and then a spike back up after the decline. I think it's important in this case, and again, you know, every ADA case will turn on its facts. I think it's important in this case to note that during the same period, she was getting only highly effective ratings from her students. She was getting ratings of superior, both from her department chair who evaluated her and from her faculty peers that evaluated her. And what that, I think, supports is an inference that the substance of her teaching hadn't really declined, even though perhaps her ability to dazzle a bunch of graduate students had declined as a result of her traumatic brain injury. And in that case, if the reaction of the graduate students that she's teaching in her classes is based upon the fact that she doesn't move as well or talk as well, or has to set up a classroom so that she doesn't have to look to the left or has to remain seated at the front of the classroom, I think that that is a form of customer preference in the disability context that the university is responsible for. And I think in that way, the university is responsible for discrimination as well. So I think if you stand back in this case, and I think if you say, well, what skin would it have been off the university's nose for the university to say, yeah, we'll give you an extra semester for your results to come in, or we'll let you go up for tenure in your terminal year, but be aware that we're going to make this exception and you can't have another terminal year. And then you look at what happened. You know, this is not a situation where the court has to speculate, well, what would have, you know, how would the tape be if it were rerun? If you look at what happened, she did very well the next year. She did very well that spring. And if she'd have had a chance to use those scores in her application for tenure, she would have achieved tenure. And that's why we think that the district court's decision has to be reversed.
Thank you, counsel. Ms. Clark.
Thank you, Your Honor. May it please the court. I want to start by saying this is obviously a very sensitive subject. No one would wish Dr. Schoper's brain injury on anyone. But the focus here is really on what happened when Dr. Schoper returned to work and on the university's evaluation of her application for tenure. Now, in May of 2015, Dr. Schoper was released by her neurologist to return. That came with accommodation requests. The university reviewed what Dr. Schoper's physician said she needed, and the university did what Dr. Schoper's physician said she needed. So Dr. Schoper says she's ready. Dr. Schoper's physician says she's ready. The physician says how she should be accommodated. The university moves forward with that. And that was 2015. So she taught the fall 2015 semester, the spring 2016 semester, and the fall 2016 semester, all before she applied for tenure. Using the criteria, the very unbiased criteria that are set forth in the collective bargaining agreement, the various levels of review and comment, the answer was no. She ultimately wasn't recommended for tenure by the president. Now, she claims that this was the university discriminated against her, but law isn't based on conspiracy theories. It's based on evidence. And essentially what Dr. Schoper is asking you to believe is that this is a discriminatory act that was committed by an entire department of her peers, her department chair, the college personnel committee, the dean, the president, and her students, that they were all in cahoots to discriminate against her. And that's not evidence, that's a theory. There's nothing that supports it, and there's certainly nothing that supports it from a but-for nature in terms of the burden of proof here. Dr. Schoper can't point to anybody who was similarly situated, who she claims was treated more favorably. There's no evidence of pretext. There's no evidence of a cover-up. And really what Dr. Schoper here is saying is, hey, listen, you're wrong about me. I am a superior teacher. I am a good teacher. But in this analysis, that doesn't matter. That's academic disagreement. And it's well known and noted in case law that, we talk about the court not sitting as a super personnel department. And that's especially true when it comes to that tenure decision. At the end of the day, Dr. Schoper, her physician, said she was ready to return. University accommodated her. She didn't want to stop the clock, and she didn't meet the criteria. At some point she had noted that, well, there were some biased remarks against her, but as the district court noted, even if you construed those remarks as biased, there are numerous different levels of review and recommendation. And I believe Judge Kirch, you had commented that, well, even the president, when we talk about the but-for nature of causation, each of these levels of review is independent. And the president is the one that gets the last word on whether to recommend to the Board of Trustees. And there's nothing here that indicates that anyone was influenced by bias. And frankly, that's the case with respect to the student comments. The student comments, Mr. Yogesh just mentioned, customer preference. Those student comments don't talk about Dr. Schoper's disability. They don't talk about her medical situation. They talk about how she has favorites in class and she treats people differently. She talks about how she regularly stresses tenure and the fact that their evaluations will weigh in her tenure decision. She talks about how much she loves the students and makes them uncomfortable. There's the student comments that were qualitative don't have anything to do with Dr. Schoper's disability. Frankly, top to bottom, there's nothing here that would support the type of but-for causation that Dr. Schoper needs to support a discrimination cause of action here. And with respect to failure to accommodate, let's take the specifics out of this. If we have a situation where an employee says, yes, they can return to work, their physician agrees, they suggest some accommodations, employer engages in that interactive process, employer does what the physician has requested, everything proceeds, employee gets some evaluations indicating that performance is not where it needs to be. And then ultimately, when it's time to separate employment, the employee says, no, I need an accommodation. Well, under our case law, that's too late in the game. And at this point, Mr. Jokic has indicated, well, the university didn't engage in that interactive process. This is on the university. Well, Dr. Schoper didn't think that she needed an accommodation either. Dr. Schoper's physician doesn't think that she needs an accommodation. She had the ability to take extra time and didn't think that it was necessary. And I do also want to add that with respect to the physician's note that Dr. Schoper submitted after she realized that she had some problems and likely was not going to be recommended for tenure, that physician's note talks about capacity. And it says that she's currently working in 60 to 80% capacity. And that soon she'll be able to return to full capacity. It's not saying that her levels of teaching are going to increase. It's not saying brain functionality will improve. It's talking about her capacity to be at work and what that percentage level looks like. But at the end of the day, this isn't the type of an accommodation that the ADA talks about. The ADA, if you look at the language, it talks about job restructuring, part-time or modified work schedules, reassignment to vacant positions, new equipment or devices. It doesn't talk about changing the criteria. We don't accommodate to put someone in a position to excel or to be promoted. That's not the standard we accommodate to. We accommodate to perform essential functions. And that really that's the case also in the in the case law cited by Mr. Jokic. In his briefs, he refers to Extran v. School District. There we're talking about, should a teacher be in a different classroom? And these were cases that Mr. Jokic has cited to in terms of the ongoing obligation of an employer to make accommodations and to engage in that interactive process. That's what we're talking about here. It's a different classroom. The Boltmeyer case was a custodian who had mental illness, who, after the fact, the school district received a note saying that, hey, this person with mental illness is not able to advocate for themselves. And this custodian, if it's possible to move the custodian to another school, to another facility, that the school district should consider doing that. Dr. Schoper can definitely advocate for herself. It's very clear that she knows how to do that. And this isn't a situation where the request is move me to a different room or adjust my, adjust the environment of my teaching facility. This is a situation where Dr. Schoper is asking for the entire set of criteria to be rewritten. What she's asking for is not a reasonable accommodation here. I believe that I had set forth the university's arguments in the written brief, and we'll let the court consider that further. If you have specific questions, I'd be happy to answer those. And if not, then I would ask that summary judgment be affirmed.
Thank you. Mr. Jokic, you have 12 seconds. So maybe just 8. Speak very quickly.
So there's a distinction between asking for tenure and asking a chance for a better chance to show that you're qualified for tenure. And I think that distinction goes to the heart of this case.
Thank you, Mr. Jokic.
Thank
The
you.
case is taken under advisement. Our next case for argument this morning is Evanson against Evanson.
Good
Mr.
morning.
Benson.
May it please the court, Josh Vincent on behalf of the plaintiff, Jeffrey Evanston and the Evanston Trusts. The primary issue in this case concerns the district court's legal determination that a deed of trust and security agreement, which I'll refer to just as the security agreement, and not by the acronym we used in the briefs for this argument, was ambiguous. And the way the district court got to that conclusion was because it believed that a settlement agreement between the parties limited their ability to create a security agreement that secured anything beyond the $1 million debt obligation that was created in the security agreement. And the court was troubled by apparently a very broad provision in the security agreement, which is often referred to as a dragnet clause or a future advances clause that picks up additional debt obligations that may occur or arise in the future between the parties. And the district court felt that we couldn't do that, and that as a result, any monies that the trust received or recovered related to the properties that were the subject of the deed of trust and security agreement had to be applied to the judgment and to absolutely nothing else. That conclusion that the agreement was ambiguous, the security agreement was ambiguous, was a legal error. First, the settlement agreement between the parties did not limit the scope of it provided for a security agreement to secure the obligation created by that settlement, but it did not limit the scope in any way, shape, or form of what security agreement the parties could enter into. They were free to negotiate whatever type of security agreement they wanted. And in fact, it was really to the parties' mutual benefit to have a future advances clause. I mean, when you are effectively joined at the hip going forward after a litigation like this that's been resolved with a security agreement that is based primarily on 8 different tracts of land with various types of debt already on some of them, and the fact that it almost creates a lending facility, if you will, because inevitably there will be circumstances where the debtor, the judgment debtor, or in this case, it was originally just the settlement amount, may need additional funds, whether it's to pay taxes on the property, whether it's to repair a roof, whatever it may be, in order to preserve the value of the security. It's really to both parties' benefit. So while Mike, the defendant in this case, could have.
Is it your position that all of the amounts that were credited against debts other than the original debts were future advances made after the settlement agreement?
So the ones that we focused on in the brief were, yes, certainly with respect to Tract 5. In Tract 5, with regard to Tract 5, in that situation, you have the trust satisfying a nearly $600,000 mortgage on the property, all to Mike's benefit. And the indebtedness provision specifically picked up that type of obligation. And it refers to other obligations created like this. It refers to loan participation agreements.
Yeah, I'm a little worried by your statement. The ones we focused on in the briefs.
Well, Judge,
the answer to my question is either yes or no. And if it's no, I wish you'd carefully distinguish prior advances from subsequent advances.
The answer is yes. Okay.
The answer is yes.
Every debt that was at issue in the litigation below, where there was a question of credit, is governed by the security agreement. And because the debt obligation, which was, part of which was the $1.2 million default judgment, also included other promissory notes, other, for example, the get that I just gave, the tract 5 payoff of senior debt on that, property taxes on that, as well. Those were all future advances that were contemplated by the settlement agreement, in fact, because it did in paragraphs 11 carve out future obligations that might be created as a result of this arrangement. Those were all things that could be applied to other debts besides the $1.2 million judgment. Those were future advances. They increased the amount of debt burden that the defendant had. Now, that's different than the Texas litigation, okay? Michael's not entitled to any credit whatsoever for the settlement of that lawsuit. That lawsuit had really nothing to do with the judgment. It had nothing to do with the settlement agreement. That was a dispute between another lien holder and the trust over, I wouldn't even say it was really over their priority because it really didn't concern that. The trust never foreclosed on its liens in that case. What they did is they had conflicting court claims against each other. This was a litigation that was spawned by Michael's, misconduct. He assigned these deeds of trust to the tracts 6 through 8 to the trust, and then turned around and disclaimed that he had any authority to do it. The trust took the position that he was in cahoots with a fellow named Lee in Texas to try and hinder or delay or defraud the trust of its interest in these properties. The Lee parties turned around and claimed that the trust was in cahoots with Michael in an attempt to try and get a superior lien position with respect to liens that he held. It really had nothing to do with Mike's debt obligation in that context. This was just a lawsuit that, Mike's conduct got the trust into. And so as a result, the trust incurred nearly a little more than $700,000 in attorney's fees in that case. They settled the case for $620,000. That money went to cover attorney's fees. There was absolutely nothing about the recovery in that instance that was attributable to Michael. He had, if you look at the Lee party's complaint in that case at docket 70-14, you'll see that they allege that he had given no consideration for his interests in the LLCs that were at issue in that case. He contributed no money to the settlement whatsoever. So from a Rule 60B standpoint, none of those payments or settlement monies that the trust recovered were attributable to Michael at all. So he gets no credit on the track 6 through 8 settlement of the Texas litigation. That had nothing to do with Michael whatsoever. It was completely wrong for the district court to have credited him with the full $620,000 of that. That was half of the judgment amount. And as I said, with respect to—
If we agree with you on the dragnet clause and find that it's not ambiguous, do we have enough to calculate all of this in the record, or is this just something where we would reverse and remand for the district court to do so?
First option I would say is I think that just based on the amounts of those, I think you have enough to reverse and reinstate the judgment. I think at that point, the onus is back on Michael. If he wants to make a new 60B5 motion asking for credit against the judgment, then I think that's the appropriate route. Alternatively, sure, you could send it back down for recalculation. But I think at this point, I think there was so much credit given just on the 2 properties that we've identified, I should say the 4, track 6 through 8 and track 5, that you could reinstate the entire $1.2 million judgment and let everybody just start over at that point. If he's got a basis, if he wants to come back in and contend that he's entitled to credit on that judgment, he can do that. And we'll go back at it. But right now, what we're asking for is that you reinstate that $1.2 million judgment. There was no ambiguity. And if you apply the security agreement as written, which is what the district court failed to do in this case, then there's absolutely no way he satisfied any portion of that judgment whatsoever. Unless the court has more questions for us, that's our position in a nutshell. I'll be happy to reserve my remaining time for the rebuttal.
Thank you.
Thank you.
May it please the court.
Alan Son on behalf of the Michael Evenson defendants. Counsel has completely ignored the merger doctrine, which is fully stated in our brief and was fully stated in the briefs below. The merger doctrine bars the recovery of anything more than the judgment and the interest. That's well-settled law here in Illinois. It's well-settled law in Texas.
I would like to start with the same place I started with Mr. Vincent. Of the money that's disputed between the parties, is all of it or some part of it properly treated as future advances? That is, advances from the trust to Michael or one of his creditors after the date of the settlement agreement.
There were advances made, but not advances to Michael. There were monies that were.
Take Mr. Vincent's example of an advance made to pay off one of the liens against the property.
Right.
So that the trust had a higher priority when that property was sold. Does that count as a future advance?
That was a future advance.
Okay.
Not directly to Michael, but in order to increase the priority of the plaintiff.
All right.
However,
so Mr. Vincent, when I pressed him, said that all of the disputes here concern future advances. Is that true, or do you take a different position?
that's not true.
Okay, so tell me which of the advances, in your view, are not future advances for
Well,
the purpose of this clause?
In the briefs below, in the argument below by the plaintiff, they did apply. In fact, they did apply monies that they collected from the proceeds of properties to a prior debt of the debt that was not included in the settlement agreement, not included in the DOTSA, in the deed of trust. Also,
can you be precise? Right, we're going to have to go when we go back. We're going to have to go and look at the record. I want you to tell me precisely which debt that is and which recovery that is, so we can look to see who's right. Because Mr. Vincent is saying all, and you're saying less than all. So which in particular?
I'd like to just answer part of your question that you answered. The money that was advanced by the trust to increase their priority was credited, they got that back. So we didn't receive, we received less than the $500,000 or so of funds that the trust advanced. It was deducted from the money that they had collected. So as far as a prior, there was a single loan.
Asking you a concrete question to identify money that the trust credited against prior debts that preceded the settlement agreement.
I have to look at the brief, but there was a prior debt which they deducted, which they said that they were entitled to deduct from proceeds that they had collected. It would take.
But you can't identify it for me.
I can't identify it at this moment.
Okay. All right.
So now there are other arguments raised by the appellants in their reply brief, which had never been made before, either in their initial brief or in the briefs in the trial court below. They alleged that they were allowed to, as a judgment creditor under the UCC, to deduct attorney's fees from the sum of money that Michael was entitled to to satisfy the judgment. But they were citing cases under the UCC which do not apply here. There was only real estate that was that was subject to the liens, and there was no personal property. And in paragraph 23 of the deed of trust and security agreement, it states that unless if I can just go to it. To further secure indebtedness, grantors hereby grant the beneficiary security interest in and to the premises insofar as such premises consist of equipment, inventory, fixture, chattel paper, documents, and so on. There was no such property. All of this property was real property. Also, the clause in the UCC does not apply here because this was a case involving a deed of trust and security agreement that had no
had no personal property. They also seek to recover for breach of contract. Now, they say they can go after the Michael Evenson defendants for breach of contract, but they elected the remedy under the settlement agreement to enter a judgment. The judgment under the law has a certain way of being executed. They wrote the judgment. It didn't have any provisions for attorney's fees, for costs. The one paragraph in the deed of trust, which refers to expenses of collection, which for the first time raised in their reply brief, refers only to expenses of collection incurred in recovering rents and other monies due from tenants. And so the expenses of collection that they seek to recover do not include attorney's fees.
Mr. Schoen, I'm
Yes.
not following you. Whose law are you applying here?
I'm applying the law of Illinois and I'm applying the clear wording of the document. The document says expenses of collection. It doesn't say attorney's fees. They would like it to be expanded to attorney's fees.
So is there some Illinois case you want us to look at that expenses of collection can't include attorney's fees? The judgment's a federal document. So Rule of Civil Procedure 69 throws us to Illinois law. So I would like to have a firm reference in Illinois law that you want us to look to.
The reference to Illinois law is that unless attorney's fees are specifically provided for by contract
Cite something.
or statute.
Tell counsel, cite something. Tell me what to look at.
What I have cited in my brief are the law of Illinois and the law that's universally recognized that attorney's fees.
Universally recognized.
In
I don't
just
want to
about
look
every
at the
state.
entire universe of cases. I want to look at particular cases. Do you have any?
I've cited cases in the brief that under the American rule, which I'll refer to you in my brief. FedNav International Limited versus Continental Insurance Company, 624 Federal 3rd, 834.
I hate to tell you, but that's not Illinois law.
It's a Seventh Circuit.
I'm asking you to cite Illinois law. The Seventh Circuit writes federal law. What Illinois case should I look at? You see why I'm frustrated. I hope you see why I'm frustrated.
Well, I can cite also Texas law under which
Texas law is not picked up by Rule 69.
But this
Rule 69 says that the right law to apply is the law of the state in which the federal court sits. That's Illinois. I'm looking for Illinois case law about what should be credited.
So I'm sorry, Judge. The facts of the FedNav case, I'm not sure if it was Illinois law or not. But there is a Texas case, and this is a Texas
law is irrelevant. So your answer to my question is you don't know any Illinois case I should look at.
I don't have that right here, and I'm sorry about that. I apologize.
Okay. Well.
Insofar as the district court's ruling regarding not allowing other debts or obligations other than the judgment, the settlement agreement was mentioned 17 times in the deed of trust. The indebtedness is defined as if in the deed of trust and settlement agreement failed to mention or include any other debt or obligation of defendants as being included in the indebtedness, except if defendants or any of them were the principal surety, endorser, accommodation party, or otherwise, and as a member of any partnership, syndicate, association, or other group.
Thank you, Mr. Smith.
Thank you.
Anything further?
Very briefly, Judge. I did want to try and get more granular with you about the tracks and the values. Track one, there was a $75,000 credit given. That's really not an issue. Track two, involving the Sadoff property, there was a rather complicated history with regard to that property, but basically monies that were recovered from the foreclosure in that instance were applied to a promissory note guarantee that we contend survived the settlement agreement, which Michael breached and cannot avail himself of its terms for release anymore. With respect to the track five, we talked about that, the senior lien, the taxes, rents, all future advances, all properly added to Michael's debt. With respect to tracks 6 through 8, there we're talking about the $620,000 recovery of the settlement. In that context, that is a collection expense under paragraph 6, which would qualify as a future advance under that context. So that's the breakdown of what we're looking at. And that's why we contend the judgment should be reinstated.
Thank you, Mr. Vincent. The case is taken under advisement. Starstone Insurance against Chicago is our next case for argument. Mr. Lee.
Thank you, Your Honor. May it please the court, Harry Lee, and I represent Starstone in this appeal. Given the time, I'm going to get right to what I believe are the two critical facts to this appeal and why the district court erred. First, the insurance policy. The policyholder in this policy controls the defense. It is the one who decides strategy, and it pays for the defense. That is a critical difference in the various cases that have been cited to the court. In each of the cases cited to the court, Sullivan, Board of Commissioners, Shorewood, Littlefield, or American Safety on the other side, the difference as to when costs are covered by a policy is whether the policyholder controls the defense. And it's a common sense commercial reason. Where the policyholder controls the defense, it can run up the cost. I'm sorry?
What Illinois case do you rely on for that proposition?
Well, it's not so much an Illinois case for that proposition, Your Honor. It is simply standing back and taking a look at what courts do.
We are interested, this being a diversity case, in what Illinois courts do in particular. One of the things that concerned me when I read the briefs is that there seems to be some indifference in the treatment. There's citation of federal cases, federal district courts, state cases. We're all trying to figure out what Illinois law says about this. Well, let me ask you the question concretely. Has any Illinois court addressed the interpretation of language like the language in this policy, the ultimate net loss clause, for example, on which the district court relied?
Your Honor, I have not seen an Illinois case, an Illinois court deal with that. I have seen federal cases dealing with Illinois law, but not an Illinois court. So it's not a matter of indifference. It may be simply that an Illinois court has not taken this issue up, but the Illinois court has taken a critical issue up in this case, the General Starr case, the Illinois Court of Appeals, and they have looked at the language of the words compensation for loss, which is the critical language in the insurance agreement, which is the language that the city says makes everything different here. Even though the word damages is replete throughout the policy.
In that case, didn't the policy, didn't include damage, the language damages or the word damages with the phrase to compensate others for loss?
I don't believe it had the word damages. Well, what the General Starr case said in looking at what compensation for loss, not compensation for loss as damages, but compensation for loss. What did that mean? What is that the definition of? And what it found is that's the definition of damages. That compensation for loss under Illinois law, Illinois Court of Appeal law, is damages. They're the same thing. So even though in one aspect of the policy, it says compensation for loss, that doesn't change the fact that what it means is damages.
So what you're saying is compensation for loss is limited to damages. Why can't compensation for loss is damages? Of course it is. But why can't it be more than that? I mean, somebody's going to pay the attorney's fees, right?
Well, it may be that there will be attorney's fees paid, but under the American rule, attorney's fees are not, you're not entitled to them.
Well, unless it's loss, unless it's, of course, damages is loss, right? I mean, compensation for loss is damages. I agree with that. That doesn't tell me a lot. I mean, that doesn't tell me compensation for loss is only damages.
Well, what it tells you is loss is different than damages, and we agree with that. Loss in this case is Mr. Rivera was held in jail wrongfully, and that's what went wrong. That is his loss. That's like his house falling down or him getting run over by a car. That's his loss. The damages are getting compensated for that loss.
But let's say he sued and he paid his attorney by an hourly rate. I mean, I would say, my gosh, I would say that is loss. I mean, I walk away. The time I spent in prison is worth $15 million. It cost me $3.5 million to collect the $15 million. That $3.5 million is loss.
Well,
I would not have otherwise spent that money, but for the fact that I spent 5 years in jail.
Right. So you expended those costs because of the loss. They're not the loss. You got damages because of the loss. They're not the loss.
Are they an additional loss?
They're an additional damage, but they're a damage which is critical in this case, which cannot be assessed against the government. So they can't be called damages. They're not allowed to be damages. And that's what the cases we've showed or cited have said. You can't make them damages. They can only be taxable costs.
I must say, I don't understand why you keep coming back to the word damages when the policy refers to ultimate net loss or the amount someone becomes legally obligated to pay. Well, ultimate net loss and legally obligated to pay are different phrases. The city was legally obligated to pay the amount it paid. Why aren't we focusing on the actual language of the policy?
I will, Your Honor. Ultimate net loss is a definition, and it is used in the insuring agreement. So to read the insuring agreement, you have to put the definition of ultimate net loss into the insuring agreement. Ultimate net loss is a relatively vanilla term. It says all sums you paid in settlement or by judgment. And you stick that in the insuring agreement, and what you get is the sums you paid in settlement judgment in excess of the retained limit that the insured becomes legally obligated to pay to compensate others for loss. So it's an incomplete thought to just look at UNL, ultimate loss. You have to then look at what the UNL was paid for. And that's the insuring agreement. And that gets us back to compensation for loss, which is damages, which cannot be attorney's fees assessed by the judge.
I just don't get it. I have Judge Kirsch's problem. The amount needed to compensate the plaintiff was $15 million. In order for him to receive all of that, the attorneys had to be paid because otherwise their lien on the judgment comes out first. So the only way to compensate the plaintiff is also to compensate the attorneys. Why isn't that covered by this? The amount that Chicago, quote, becomes legally obligated to pay to compensate others. It's legally obligated to pay the lawyers, we will say, $3.75 million. in order to fully compensate the plaintiff. I mean, that's just the language of the policy.
But Your Honor, in the attorney's fee situation, they can't be damages. It's against the
Policy
congressional
doesn't
act.
use the word damages. It uses the phrases that we have been quoting
Well,
and from which you seem to be running full tilt.
for example, Your Honor, the policy uses the term Starstone will be, quote, liable only for that portion of damages in excess of the SIR, close quote. It says Starstone, quote, will pay for the total of all damages for all losses, close quote. So damages and losses are different. Damages are categorized by the court the way they are, and they cannot be, the attorney's fees cannot be damages. Your Honor, because the time is so short and I have only about 25 seconds left, I'd like to make sure we don't lose sight of the fact that there's also an exclusion. That exclusion says that Starstone will not pay for any claim for relief other than monetary damages. The City of Dearborn case by the Sixth Circuit, understandably.
Is that the language of the exclusion?
Yes. Yes, the language of the exclusion
No.
is
It says any form of relief.
any form of
The
relief.
form of relief is money.
Well, the relief, the relief prayer in the underlying complaint seeks three things. It seeks compensatory damages, attorney's fees and costs, and punitive damages. Those are the forms of relief that are sought by Mr. Rivera. And in light of that fact, the form of relief being attorney costs and fees, those are excluded because they are not monetary damages. If it'd be all right, I'd like to reserve the 30 seconds I have left.
Certainly, counsel. Rodriguez.
May it please the court. Summary judgment for the city was correct. The attorney's fees and other costs at issue in this case are plainly within the policy's coverage grant, and their coverage is not precluded by any limitation or exclusion in the policy. As the court properly observed or correctly observed, the policy's coverage grant uses the broad inclusive word loss, not the word damages, to specify the type of compensable harm.
My principal question to you is the same as my principal question to Mr. Lee, which is, has any Illinois court dealt with the interpretation of language like this in an insurance policy?
We're not aware of one either.
Yeah.
So
Well,
the
it's
plain
not there,
language.
it's not there, but it would be better in a diversity case if it were.
Yeah, so the plain language of the word loss, I think, should carry the day. And that means that loss would include all types of loss that victims incur, including any attorney's fees and other costs they must pay. Starstone wrongly asserts that the coverage grant covers only damages, even though the grant does not contain the word damages or any variant of it. And the drafters of the policy could easily have used the word damages if they had wanted the coverage grant to cover only damages. Starstone has the burden with respect to any limitation in the policy, and it fails to meet that burden. It relies on two provisions in the policy's limitation section, but ignores their context. Those provisions do not undo the policy's coverage grant. Rather, they simply explain how much in dollars Starstone will cover and when its obligations arise. The first of the provisions, section 3G2, concerns how much Starstone will cover. It describes the aggregate limit of Starstone's obligation to pay the city for wrongful acts. That is not at issue in this case because the aggregate limit of Starstone's obligation under the policy is $5 million, while the city's claim is only $3.75 million, well below the aggregate limit. The other provision in the limitations section on which Starstone relies is the last sentence of section 3. But the point of that provision is simply to specify when Starstone's liability under the policy arises, which the provision says is after the city has exhausted its self-insured retention. Starstone pulls the word damages from those provisions, as if pulling a term out of its context could somehow override the policy's coverage grant by converting the type of compensable harm for which the policy provides coverage from losses to damages. It cannot. In fact, this is made clear by two other provisions of the policy that Starstone ignores, sections 3B1 and 3E. Each of these provisions pairs the term damages with occurrences, while it pairs the term losses with the term wrongful acts. The settlement of the underlying litigation pertained to claims that were based on wrongful acts as defined in the policy, not occurrences. This supports that the type of harm in this case that is compensable under the policy is losses, not merely damages. Starstone also relies on a sentence in section 1B1 as a limitation, even though that provision is not even in the policy's limitations section. We explain in our brief why that contention is forfeited, but regardless, the provision pertains to defense costs, not costs that a plaintiff received in a settlement, like the attorney's fees and other costs at issue in this case. Starstone likewise has the burden with respect to any exclusion in the policy, and it fails to meet that burden as well. Two of the policy's provisions expressly exclude costs for claims involving asbestos and claims involving nuclear energy. But there is no similar provision for wrongful imprisonment claims like those at issue in the litigation underlying this case. This supports a conclusion that the policy does not exclude costs, including attorney's fees, at issue in this case. Starstone relies on only one exclusion provision, but does not even mention fees, but that provision does not even mention fees or costs. It says that Starstone, quote, will not pay for claims or suits against the city for injunctions, equitable relief, or any other form of relief other than monetary damages. This provision precludes payment for claims or suits that are equitable in nature, and it expressly does not exclude payment for claims or suits that are for monetary damages. All the claims at issue in this case were for monetary damages. Thus, the provision does not exclude payment for them. We ask the court to affirm the judgment.
Thank you, counsel. Mr. Lee, you have 23 seconds. Walk fast.
Very briefly, Your Honor. The policy uses the word damages throughout the policy, including the definition of damages, compensation for loss, number one. Number two, I asked the court to look to City of Dearborn, given the lack of Illinois law. It is a case which has the same insuring agreement and the same exclusion and finds the way Starstone asked the court to find. And last, I just note that there is no place in the policy anywhere that says Starstone ever pays costs. Thank you, Your Honor.
Thank you. The case is taken under advisement. Case number 5 today is MTB against Garland. Mr. Buck.
Good morning, Your Honors. May it please the court. My name is Lavanga Vijayakun, and I am representing the petitioner in this case. Because the immigration judge and the Board of Immigration Appeals committed factual and legal errors. My client, MTB, faces deportation to Mexico and the substantial risk of torture at the hands of the Sinaloa cartel.
What about the government? Where's the government acquiescence argument?
Your Honor, the government acquiescence point, I'll first mention that it wasn't the denial of the relief that was requested by the agency did not turn on that point, and therefore I would say that it is outside the scope of this appeal. But nonetheless, Your Honor, with regards to the acquiescence, the expert in this matter did testify to that. He said that under these circumstances, where a particular individual has been directly threatened by a member of the Sinaloa cartel, and he has cooperated with U.S. law enforcement such that his sentence has been dramatically reduced, that under those circumstances that the Sinaloa cartel would get to him. And the reason why the Sinaloa cartel would be able to get to him is because they act as a de facto government in so many of the states, roughly half of the states of the country. The expert also testified to the fact that there are government officials on the payroll of the Sinaloa cartel. The Mexican government may have tried to bring the cartels under control, but there is no proof that they have. And I would point, Your Honors, to Rodriguez Molinero versus Lynch, which is a Seventh Circuit case, Judge Posner's decision, where he discussed this acquiescence point. Certainly, you do not need to have the entire government's acquiescence here. Even if there is the possibility that there are police officers or local state officials who cooperate with the Sinaloa cartel in allowing for this type of torture, that should be enough to meet the more likely than not standard. Your Honors, this court's review is under a substantial evidence standard. Based on that, we ask that this court grant relief under the United Nations Convention Against Torture. And to assist with that review, Your Honors, I'd be happy to walk through these errors that the immigration judge and the BIA committed. First, as I mentioned, there are two main reasons why MTB is at risk of torture here. First is it has to do with the family vendetta. MTB's in-laws are drug traffickers. They're tied to the Sinaloa cartel. There is a family vendetta against MTB. And one of the members, the Sinaloa cartel members, who is also a family member, threatened MTB with cartel violence. That's the first reason. The second reason is that MTB cooperated with U.S. law enforcement, which led to his dramatically reduced sentence, reduced by 4 years, by the way. And his cooperation with the U.S. law enforcement is public knowledge. In looking at these two reasons, Your Honors, the IJ erred in finding, as well as the BIA erred in finding that there is no testimony that his in-laws are cartel members. That is demonstrably false. I draw the court's attention to pages 127 to 28 and 155 to 57 of the administrative record, where MTB testified to the fact that his brother-in-law, JV, is a Sinaloa cartel member. MTB testified that JV trafficked meth from Sinaloa. JV, quote, worked with the cartel, unquote. JV, quote, was directly involved with the cartel, unquote. And when JV threatened MTB, he used the phrase, "my people from Sinaloa." Under this more likely than not standard, Your Honors, it would be in clear error for the immigration judge to say that his brother-in-law was not a Sinaloa cartel member. Another big error that the immigration judge and the BIA made is that they found that there was no evidence that MTB was actually threatened. Again, this is demonstrably false. I'll point the court to administrative record pages 116 to 117, where JV, in the context of a jail fight, where MTB was present and JV blamed MTB for not backing him up during the jail fight, JV turned around and threatened him and said, quote, "I'm going to have my people from Sinaloa take care of you," unquote. Again, this is an error that the IJ and the BIA both made. There's also the IJ and the BIA both also say that the reduced sentence will not arouse suspicion. And the reason why the IJ and BIA say this is because the lowered sentence falls within the range of sentences that his co-conspirators received. But this misses the point. MTB's sentence went from 144 months to 96 months. That is a huge reduction of 4 years there. The co-conspirators' sentences may have been in the range of 96 months from the outset, but they didn't have a reduction in sentence. MTB did. And it is that reduction that is of significance here. On top of that, there are public documents, I'll point to AR 731 to 37, that actually establish, that mention the fact that he received a reduced sentence and that that the reduced sentence was as a result of, and it cites to Federal Rule Criminal Procedure 35B, which stands for sentence reduction on the grounds of substantial cooperation in prosecuting another individual. On top of this, his brother-in-law has been tracking his sentencing and his out date, so to speak. And when I say brother-in-law, this is the brother of JV, who was involved in the jail fight. On top of that, before the sentence reduction occurred, MTB told his wife that I was ready to cooperate. He used those words and he testified to that. And I'll point the court to 131 to 32 and 154 in the record where he testifies to this. Again, this is another error of the immigration judge and the BIA, in which they found that he never told his family. He clearly did tell his family that about his cooperation. Ultimately, honors, we're talking about a drug cartel here, and they're not known for following due process. They shoot and then they ask questions if ever they do, and snitching, which is what he did, which is how he will be seen, is considered one of the worst transgressions against the cartel, as the expert testified. And even the suspicion of cooperation, of being an informant, it doesn't have to be airtight. Even the suspicion of cooperation would be sufficient for the cartel to take action. The last error, I see that I'm close to my time here, but the last error I'll identify here, Your Honors, is that the IJ and the BIA said that relocation to Mexico safely was possible. That is the wrong legal standard. The legal standard is not about whether it's possible, it's whether it's reasonable. In this case, it is not reasonable. Sinaloa cartel is the most powerful criminal organization in Mexico. And when the expert was asked, can MTB be safely relocated? He was unequivocal. He said, no, it's extremely difficult given the power and presence of the Sinaloa cartel. And that is on page 172. On top of that, Your Honors, cartel territories are constantly in flux. There's no such, for the government to say that, oh, he can be relocated to a state where the Sinaloa cartel is not dominant, it would be unreasonable for a layperson like MTB to constantly research and track where each cartel's territories are at any given day, given the fact that they are in flux and they're constantly negotiated. Given that, it would be unreasonable for us to expect that he would live in hiding. On top of that, MTB's own circumstances need to be taken into account. Here, there was a family vendetta that was driving the risk. And that family knows the places that he would go in Mexico. They know his family and friends in Mexico. So they know how to access him. I see that my time is nearly up, so I'll wrap up and reserve whatever time I have for rebuttal. Thank you.
Thank you, counsel. Mr. Rabbits.
Please the court, your honors, Tim Ramitz on behalf of the United States Attorney General. This immigration case, the record does not compel the conclusion that petitioner established a clear probability of torture in Mexico. Petitioner starts with the two errors that he proffered the panel. That there was an error about interpreting his testimony to mean that his brother-in-law JV was a cartel member. There's an error about who knew about his cooperation. But this is just a part of the case. The other essential part of the case that petitioner briefly touched upon only is that there are other layers of speculation that the immigration judge found inherent to his claim that sunk his claim for protection. That is that even assuming that JV was a cartel member, even assuming someone knew about his cooperation with federal authorities, there was only speculation that anyone would be able to locate him in Mexico. He has no good answer for this because what he testified was that maybe his wife, SV, would tell someone, but that didn't make any sense because in the record, she only helped him over and over again. She paid for his legal fees and declined paying for JV's legal fees. She maintains somewhat friendly relations with him. They have children together. And there's no reason he's ever presented for why she would tell her brothers, who she knows has a dispute with him, about his whereabouts in Mexico. And that's just the end of his case right there. But on top of that, you also have the relocation finding. It is a good finding on this record. His own expert, Dr. Rosen, testified that Sinaloa cartel is surely powerful, but it's only operative in 15 to 17 of the 52 Mexican states. There's rival cartels in the other states. There's 3 states where there's no cartel presence in the South, Quintana Roo, for example. So even assuming there are these errors in the records, his claim still fails. But just to briefly touch upon those errors, it's not an error for the immigration judge to find that JV was not a Sinaloa cartel member because petitioner never said that. He even equivocated in his own testimony. He said he was pretty sure they're cartel members, but he ultimately didn't know. And when it comes to whether or not anyone knew about his cooperation with federal authorities, it was the same. He said he told his wife that he was ready to talk to authorities, but in the very next passage, and they asked him, did she ever acknowledge that she knew you cooperated? And he said, no, she never acknowledged that. So it's just layer upon layer speculation. Anyone know he cooperated? Unknown. Does anyone know if the family are cartel members of the Sinaloa cartel? No one knows. And on top of that, no one knows they could relocate him in Mexico. And on top of that, it seems he could relocate in Mexico. Unless the panel has any further questions, the government yields its time.
Thank you very much. The case is taken under advisement. Our final case of the day is Napier against Orchard School Foundation. Mr. Darst.
Thank you, Your Honor. May it please the court. Richard Darst for Jamie Napier. This is a case of gender discrimination against a male director of the Orchard Middle School in Indianapolis. Mr. Napier had exemplary past performance, but Orchard debated not hiring him because he is a male. Orchard made other statements against males, including that there were too many males and that the male applicant for the position of the head of school would have a huge disadvantage and a big challenge. Orchard added, aside from the legality of that position. Orchard did hire Mr. Napier as director of the middle school and gave him a good evaluation. The new female head of school, who was later hired after him, gave him a good recommendation for the position of head of school at a private school in Louisiana. But he was unable to pursue that position because his wife, who is a full professor in chemistry at Butler University, was unable to transfer to a suitable position or an equal position. When he came back to Orchard and said he was going to stay at Orchard, then the new female head of school terminated him based on vague false statements about him.
Going back a little bit before his termination, the new female head of school, Dr. Sherry Helvey, in her first 2 weeks at Orchard, demoted the male director of the middle school, Mr. Napier, and the male director of the elementary school from the senior leadership team that they had been on for the years they'd been there. She replaced the 2 male directors with 2 females who did not supervise any teachers, which is very unusual for a school. The new female head of school told the 2 male directors not to communicate directly with her, but to communicate with her through the male assistant head of school, Mr. Nick Ebley. The new female head of school did not give information to the male assistant head of school, Mr. Ebley, and to the 2 male directors, Mr. Napier and the director of the elementary school. The lack of information to the male assistant head of school and the 2 male directors of the schools caused the male assistant head of school to be afraid to complain to the female head of school, even about a health problem of nuts being in a cake that she had brought to the school. The lack of communication then caused the termination of Mr. Napier from the false allegations that the head of school later made against him. The male director of the elementary school resigned without other employment the following year. He was replaced by a female, less qualified, who had been a teacher, who did not have supervisory responsibility. And Mr. Napier was replaced by his coordinator, who had no supervisory experience or administrative experience, and did not apply for the position, did not want the position. For the next 2 years, the new female head of school promoted and hired only females for leadership positions. So Ms. Brothers, Angela Brothers, was the middle school coordinator, working with Mr. Napier, and had done so for a few years. They worked together well. She complimented him and wanted to work with him, and they were working together very well. And her statement to that effect to the new female head of school is at appendix page 47. She asked, would you let me please work with Mr. Napier and his secretary, Carol? She did not want the job of Mr. Napier as director of the middle school. She had no supervisory experience. She was not qualified for the job. When the new female head of school told Mr. Napier that his job would not be renewed and offered the job to Ms. Brothers, the coordinator, she called Mr. Napier and said, "What am I going to do?" He told her that if she did not accept the job, both of them would be out of a job and the school would fall apart without him and without her. So she accepted the job. She had been told before this that the new female head of school planned to demote her, that is Ms. Brothers, from the coordinator position to a teaching position. But after Mr. Napier came back from Louisiana and said he was going to stay at Orchard, the new female head of school made false allegations against him and told Ms. Brothers, whom she had told was going to be demoted, told her that she wanted to promote her to director. We have many types of evidence of the gender discrimination against Mr. Napier, as well as other males at the middle school. The court has said that one type of evidence can be sufficient if it's strong enough, Truth versus May department stores. Mr. Napier has many types of evidence. He has more types of evidence than the evidence in the recent decision of Vicio versus U.S. Foods. as well as more evidence than Coleman versus Donahue, Herrick versus Indiana University, Purdue University, Fryer versus Seaford Shaw, Salter versus Walmart. The false statements of the new female head of school. Well, first of all, before her false statements, her actions show that she did not trust the males, did not give the males information, but did trust the females and gave them information. When Mr. Napier returned from Louisiana, said he's going to stay at Orchard, she said that she told Ms. Brothers that she wanted Ms. Brothers to be demoted to teacher. And this caused Ms. Brothers great stress, caused her to cry at the school, caused her to tell the coordinator of the elementary school, which caused the coordinator of the elementary school stress as well. Ms. Brothers then, or excuse me, Ms. Dr. Helvey, the new female head of school, turned around the blame from her, causing Ms. Brothers to cry and the other coordinator stress, turned that problem around and blamed Mr. Napier, who had not caused any stress to Ms. Brothers, had been trying to save her job and did not cause any stress to the coordinator of the elementary school, which was confirmed by the affidavit of the coordinator of the elementary school that she had also worked well with Mr. Napier. And it was Ms. Dr. Helvey, who was a new female head of school, who had caused the stress on Ms. Brothers and the elementary coordinator. That was caused initially, stress was caused initially by the female head of school by having a committee formed who told Ms. Brothers, and Ms. Brothers was not qualified for the job of coordinator. And Dr. Helvey also hired consultants from Butler University who interviewed Ms. Brothers and the elementary school coordinator and about their job descriptions, indicating to them that their jobs might be in jeopardy or and stress them. Dr. Helvey attempted to blame Mr. Napier, but when Ms. Brothers asked Mr. Napier if her job was in jeopardy, he did not say one way or the other. He said, maybe, and proceeded to try to write a job description that would help her, not cause her any stress. Orchard said that Mr. Napier was given an instruction on confidentiality, but there was no instruction in the written instructions on confidentiality, which are at appendix page 43. There's no verbal instruction. Dr. Helvey had tried to use different words to describe an instruction, but the words kept changing and shifting. My gosh. Thank you.
Ms. Billingsley.
May it please the court. My name is Jessica Billingsley. I represent the appellee, the Orchard School Foundation. Today, I urge the court to affirm the decision of the district court because no genuine issue of material fact exists upon which a reasonable jury could find that Orchard terminated Mr. Napier because he is male. I'll start with appellant's last point. It is undisputed in the record below that Dr. Helvey instructed Mr. Napier to review and rework the job description of the middle school coordinator. Dr. Helvey further instructed Mr. Napier to undertake this project in confidence. It's undisputed that Mr. Napier did not follow that instruction and instead divulged to the middle school coordinator that he was undertaking a review and her job may be in jeopardy. Second, it's undisputed that Dr. Helvey instructed Mr. Napier not to post an advertisement for a vacant teaching position until she had spoken to the head of another private school. Again, Mr. Napier ignored this instruction and posted the job vacancy anyways. Because of these two reasons, these two undisputed reasons, the head of school terminated Mr. Napier's employment. Now moving to some of the factual allegations, Mr. Darst asserts make a factual or genuine issue of material fact for this case. First, here first to Mr. Napier's exemplary performance, but that performance occurred in the past. He's referring to a job evaluation in the spring of 2017 from the former head of school. That was almost a year and a half before the events leading to his termination in the spring of 2019. He also cites the statements by parents and subordinates, individuals who had no knowledge about the underlying facts that were the basis for the ultimate termination. Next, he refers to statements made by others within Orchard community that all occur prior to Dr. Helvey arriving to Orchard. And there's no evidence in the record to suggest that Dr. Helvey was aware of these statements or that they somehow influenced her hiring or firing decisions. Third, Mr. Napier cites to Dr. Helvey's February 2019 recommendation, but the timing here makes a difference. That recommendation came early in February of 2019 before Dr. Helvey became aware that Mr. Napier had violated her confidence in divulging the job description task to the middle school coordinator. Mr. Napier also cites to the resignation of Mr. Schwartz, the elementary school counterpart to him. Mr. Schwartz resigned because his family was relocating to a different state, not for any untoward reason. And he states such in his affidavit that's a part of the record below. Mr. Napier also cites to questions about the qualifications of those individuals that took both his position and Mr. Schwartz's position. But there's not a significant difference here. Angela Brothers, who is now the permanent middle school director, has similar education. She has a master's degree in curriculum and was working in the Orchard School for 20 plus years at the time she was selected to take that permanent position. Finally, the statement that females in leadership, or that Dr. Helvey rather, undertook some campaign to replace males in leadership at Orchard with females isn't carried out by the facts in the record. Instead, it's truthful that Dr. Helvey in 2020 hired a male for DEI position, diversity, equity, inclusion, and then also a male in 2022 for the financial support position at the school. And then finally, Mr. Napier cites to the fact that, or alleges that there's more evidence in this case than in this circuit's recent opinion in Vicchio. That's not the case. Vicchio represented a situation where a new supervisor came on and within the first 25 days issued the first negative performance evaluation that employee had received. In addition, there was evidence to support more or less a campaign seeking that individual's firing, emails saying, what can we find that that individual has done wrong today? They also started searching for a replacement before they had ever terminated that individual. For those reasons, Your Honor, unless there are other questions, I would urge you once again to affirm the district court's decision.
Thank you very much. The case is taken under advisement and the court will be in recess.